Welcome to the McCabe Centre for Law and Cancer Council Victoria's webinar, New Advanced Care Planning Laws, Communicating Your Future Healthcare Decisions. My name is Jonathan Liberman. I'm Director of the McCabe Centre for Law and Cancer, and I'll be your host this evening. Our event will be recorded and made available on the Cancer Council Victoria website next week. You may wish to view it again or recommend it to others. Before we begin, we would like to acknowledge the traditional owners of the lands we are meeting on today. We also pay our respects to their elders past and present and all Aboriginal people participating today. If you have any connection problems during the webinar, please call the numbers on your screen, quoting the meeting number provided there in bold, 578 706 224. Tonight's webinar will run for an hour and a half. The first section of the webinar will consist of presentations from our expert panellists and then a panel discussion. For those of you who have not participated in a webinar before, you don't need to do anything during this time, just sit back and enjoy the presentations. You may like to have a pen and paper ready to make some notes or jot down questions that you can ask later in the evening. Towards the end of our session, we'll have a live Q&A segment. At this time, those attending the webinar can post a question to the panel using the question and answer function in the webinar software. During the question and answer time, the presenters will offer live responses to questions that come in from participants. And a disclaimer before we start, the content in this webinar is general information only. It's not intended to be legal advice and it shouldn't be relied on as such. The legal information in this webinar is specific to Victoria. For information about advanced care planning laws in other states and territories, please see the website that we have on the slide there, which is the Queensland University of Technology. Okay, so why a webinar on advanced care planning? The law in this area hasn't traditionally been well understood. We ran a couple of webinars in 2015 to inform people about how the law could support them to have a say in their future healthcare. One of those was for people affected by cancer and those who care for them, and the other one was for health professionals. Now that the law has been changed by the Medical Treatment Planning and Decisions Act 2016, we're running another two webinars to discuss advanced care planning options and the key changes. The next one, which is for health professionals, will be at 5:30 Tuesday next week, and you can again register via the Cancer Council Victoria website. Why is advanced care planning important? It serves a number of functions. It helps you consider your values and think about medical care you would or wouldn't want in the future. It guides medical decision-making about you if you lose the ability to make your own decisions. And it can support your loved ones to feel confident that they're making the decision you would want them to make. As we go through the changes in the legislation, it's important to note that they won't take effect until March 2018. And now I'd like to introduce Dr. Deborah Lawson, McCabe Centre Legal Policy Advisor. Deborah will be talking about advanced care directives and the key changes to these under the new legislation.
Thanks, Jonathan, and hello everyone. Some of you might be wondering why we're talking about advanced care planning in the law and what the law has to do with advanced care planning. You might think of advanced care planning as a purely health or a medical issue. So I wanted to begin by highlighting that the law has a role in advanced care planning in two key ways, and that's through enabling you to appoint a medical treatment decision maker to make medical decisions for you if you become unable to communicate or to make your own decisions, and through enabling you to complete advanced care directives, which are documents that record your preferences, values and decisions about medical care that you would or wouldn't want in the future if you become unable to make your own decisions. And it's important to remember throughout this webinar that these processes for decision making in respect of your medical treatment only kick in if you become unable to make your own decisions. For example, if you lose consciousness. Otherwise, you'll be the one who continues to make your own medical decisions. There are a few different advanced care planning options to consider, including appointing a medical treatment decision maker to make decisions for you, recording your preferences and values, doing both or doing neither. For some people, simply appointing someone who they completely trust to make the right decisions for them may be all that they want to do. Others might choose to record their preferences or decisions in writing without appointing a medical treatment decision maker. One of the benefits of doing both is that your medical treatment decision maker will have a good understanding of your preferences if they have a written document to refer to also, and that might be particularly useful if they're in a stressful or an emergency situation where a difficult decision needs to be made quickly. Or it can also be useful if there's something that you feel particularly strongly about that you want to ensure your medical team knows about. Other people might not be interested at all or choose not to undertake any advanced care planning. You can participate in advanced care planning as much or as little as you want. It's totally up to you. It's just about knowing what your options are and considering what's right for you. So the aim of this webinar is to give you information about your options and planning for your future medical care, and to let you know about the key changes to advanced care planning that will occur under the new law, which Jonathan mentioned was the Medical Treatment Planning and Decisions Act. So when should people consider advanced care planning? Again, whenever feels right for you. It can have value for people at any stage of life, particularly appointing a medical treatment decision maker. If any of us were suddenly hit by a bus, for example, then we might be reassured to know that we've appointed someone who understands us and our values to make any important medical decisions for us. Recording your preferences in writing might be particularly useful for people with medical conditions, particularly chronic or advanced disease, or people undergoing risky medical procedures. If you are going to do it, advanced care planning must be done before you lose the ability to communicate or to make your own decisions, because you need legal capacity to undertake these processes. And capacity is the ability to understand, to remember, to use and communicate information which is relevant to advanced care planning. So my part of the webinar presentation will focus on your options for and the consequences of recording your preferences in writing. Sandra will next talk about appointing a medical treatment decision maker to make decisions for you and how that person is expected to make those decisions. At this point, only people with a current medical condition can complete a legally binding advanced care directive, and even then only to refuse medical treatments. They can do this by completing a refusal of treatment certificate. There's currently no option to provide legally effective consent to treatments that they would want to receive. There are other advanced care plan documents, such as a statement of choices, for example, but the law in Victoria has been unclear about whether health professionals are legally obliged to follow these, although they have always been and will remain strong evidence of your preferences and values in relation to medical treatment. So what's new in advanced care directives? Under the new law, anyone with capacity will be able to make a legally binding advanced care directive. You won't need to have a current medical condition to make one. As well as being able to refuse treatments that you wouldn't want, you'll be able to provide legally valid consent to treatments that you would want through an advanced care directive. And there'll be two options for recording your preferences. You'll be able to do either or both of them. So you'll be able to make an instructional directive, which allows you to provide specific directives about treatment you would consent to or refuse. and or a values directive, which details your preferences, values and wishes, which medical treatment decision makers and health professionals must consider in making medical decisions for you. As I mentioned, instructional directives will provide specific directives about treatment you consent to or refuse. So, for example, you might include a statement that you consent to a heart bypass operation in specific circumstances, or you might include a statement that you refuse CPR. But note that you can't demand treatment in an advanced care directive, in an instructional directive. Health professionals don't have to provide treatment that they don't think will benefit you or enhance your quality of life. So in effect, what an instructional directive does is provides directions about medical care in case a health professional chooses to offer you that care in the future. You're not able to compel a health practitioner to provide treatment. And instructional directives are perhaps most useful if you have advanced illness and you know the likely options and outcomes and you feel very strongly about them, or you're very clear about the treatment decision you would make in the future, or there's no one you would want to appoint as your medical treatment decision maker, or your family are likely to disagree about what treatment you would or wouldn't have wanted. You might be wondering whether your instructional directive could be ignored or overridden, for example, if people disagree with what you've written. In limited circumstances, they can be overridden. If a health professional believes on reasonable grounds that circumstances have changed since you made your directive, so that if they followed it, their actions would no longer be consistent with your preferences and values, they should apply to VCAT for an order about the directive. And this is most likely to arise in circumstances in which you have refused treatment that a health practitioner is concerned you might now actually want if you could make your own decision. VCAT can order that your directive doesn't have to be followed if it's satisfied that circumstances have changed, so that following it would no longer be consistent with your preferences and values, or if they think that you've relied on incorrect information or assumptions when you made the directive. If there's no time for the health practitioner to apply to VCAT without causing serious deterioration for you, a health professional may refuse to follow the directive. But unless it's an emergency, they would still need to get consent from your medical treatment decision maker to provide treatment to you. So health professionals can't provide treatment against the directive without asking anyone. Except emergency situations are different. A health practitioner can provide treatment to you if they don't know that you want to refuse it. So if you do want to refuse treatment, it's really important that you let people know and that you provide copies of your directive to all of your healthcare providers, and keep a copy handy so that emergency doctors or paramedics might easily find it in an emergency situation. Turning to values directives, these are statements of preferences and values as a basis on which you'd like any medical decisions to be made about you. It can include statements about medical treatment outcomes or the quality of life that you consider acceptable. For example, if I'm unable to recognise my family and friends and can't communicate, I don't want any medical treatment to prolong my life. Or if a time comes when I can't make decisions about my treatment, I'd like to receive any life-prolonging treatments that are beneficial, including research procedures. Values directives provide guidance on how a decision can be made that fits with your values. You might want to make one if you don't have strong views about particular medical treatments you would really want or really wouldn't want, or if you'd like to have more of a values-based conversation and provide more written information about your preferences and values in respect of a range of different medical care options. And they can be as simple or as detailed as you like. If you've got religious beliefs that might affect your healthcare decisions, you can include those. You could also mention people that you'd like to be consulted about your healthcare, so they might not be your appointed medical treatment decision maker, but it would provide strong evidence that you'd like them to be consulted. And Sandra will speak in more detail shortly about how health professionals and your medical treatment decision maker will use your values directive to make medical decisions for you. So how do you complete one? You can't complete one of the new advanced care directives yet. The Act comes into force in March next year. The government's currently working with the Office of a Public Advocate and others to develop resources to support people to understand and to make advanced care directives. There won't be prescribed forms, so there will be some flexibility in the format of the Advanced Care Directive that you complete. However, there will be some formal requirements. Advanced Care Directives will need to be in writing in English, include your name, your date of birth, your address, be signed by you, be witnessed and signed by 2 adult witnesses together, one of whom must be a registered medical practitioner. The person you appoint as your medical treatment decision maker can't be a witness to your Advanced Care Directive, and both of the witnesses have to certify that you have decision-making capacity, you're freely and voluntarily signing the directive, and that you appear to understand the nature and effect of each of the statements you're making. Once you've completed an Advanced Care Directive, it's really important to tell people that you've made one if you want your preferences and decisions to guide your future medical treatment. Keep a copy for yourself and give copies to your GP, your oncologist, the health services you attend, your medical treatment decision maker, your lawyer, and family members or friends who might be involved in your treatment. Ask your doctor or health service to place a copy on your medical record. You might also want to stick a copy on the fridge or wherever you keep your medicines and upload it to your My Health record if you have one. If you change your mind about what you would want or wouldn't want down the track, then you can change or revoke your Advanced Care Directive by following the same processes that you followed in making it. So it needs to be signed in writing and appropriately witnessed. But even if you don't change your directive, but you do change your mind, you can express your views and preferences as long as you're able to, even if you don't have capacity to make a particular medical decision. And these preferences and views must be considered by a medical treatment decision maker. And finally from me, if you've already completed a refusal of treatment certificate or another form of advanced care plan, then you might be wondering what will happen to these documents when the new law comes in. A refusal of treatment certificate will continue to apply in the same way unless you cancel it by clearly expressing your wish to cancel it, or unless it's no longer applicable because your current medical condition has changed. Other advanced care plans will continue to provide strong evidence of your preferences, views and values, and should therefore be carefully considered by medical treatment decision makers and health professionals. I'll now hand over to McCabe Centre Senior Legal Policy Advisor Sondra Davrin to talk about changes to medical treatment decision-making processes.
Thanks, Deborah, and hi everyone. Tonight I'm going to go through the key changes to the new Medical Treatment Planning and Decisions Act makes to substitute decision making, and some of those key changes are listed here on the slide. So a medical treatment decision maker is a person with the authority to consent to or refuse medical treatment on behalf of a patient who does not have decision making capacity. And at the moment, they are known generally as substitute decision makers. Under the new Act, they'll be called medical treatment decision makers. They can be appointed under a formal process, or they can be recognised under legislation. Under the new Act, all medical treatment decision makers will have the same powers. So, for example, there will no longer be the difference between decision makers who can refuse treatment and those who can't. So a person can formally appoint a decision maker at any time, or you can appoint one if and when you make an advanced care directive. So you don't have to have both a medical decision maker and an advanced care directive, but it is important that your medical treatment decision maker knows about your preferences and values, whether these are communicated in an advanced care directive or in another way. VCAT, which is the Victorian Civil and Administrative Tribunal, can also appoint a guardian with the power to make medical treatment decisions. And a VCAT guardian is usually appointed in cases where there is a person with a disability who's unable to make decisions about their personal affairs, including decisions about medical treatment. If you want to appoint a decision maker yourself, then there are some formalities, as there are now under existing power of attorney and guardianship laws. Under the new Act, the formal requirements for appointing a decision maker are the same for all medical decision makers. And the formal requirements are listed on the slide here. And as they're quite similar to the requirements for making an advanced care directive that Deborah has already mentioned, I'm not going to go through them in detail. But it is worth noting that a person who accepts an appointment as a decision maker must make a statement to the effect that they understand the obligations of being a decision maker and that they undertake to act in accordance with the person's preferences and values to promote the personal and social well-being of the person making the appointment, and that they have read and understood any advanced care directive. It's also worth noting that these appointments are not set in stone. So the appointment of a decision maker can be revoked by the person who made the initial appointment, or it can be revoked by VCAT if this is needed, or a decision maker can resign. If you decide to revoke the appointment of your decision maker, you have to follow the same procedure listed on the slide here. If your decision maker decides to resign, then this has to be communicated in writing by the person resigning and witnessed. If there is no relevant instructional directive or appointed medical treatment decision maker, then family members or carers can be recognised as a medical decision maker and make decisions for a person without capacity. Currently, under the Guardianship and Administration Act, there is a hierarchy of people who can be recognised as decision makers, and these people are known as the person responsible. The new Medical Treatment Planning and Decision Act replaces that list with a shorter, simplified list, as seen on the slide here, and adds the additional requirement that the recognised decision maker must have a close and continuing relationship with the person they are making a decision for. So for those who are familiar with the existing list would know that that list is a lot longer than this one. It includes all the different possible substitute decision makers under different laws, and then all the nearest relatives in relation to a person. And these are sons and daughters, parents, grandparents, grandchildren, uncles, aunts, nephews, and nieces. As you can see here, the new shorter list is limited to spouses or partners, carers, adult children, parents or adult siblings. And if there is more than one child, parent or sibling, then the eldest child, parent or sibling will usually be the recognised decision maker. The new Act will also require that a recognised decision maker must have a close and continuing relationship with the person they're making the decision for. Close and continuing relationship isn't defined in the legislation. It will most likely have to be assessed on a case-by-case basis. It is designed to ensure that distant relatives or close relatives that have no connection to a person will not be making medical treatment decisions for a person. So as well as simplifying the list of who can be a decision maker, the new Act will also change the way a decision maker comes to a decision. But currently there are different tests to assist medical treatment decision makers, including the best interest test, or the requirement that a decision be consistent with the person's wishes. And these tests have been criticised for either being too subjective in the case of the best interest test, or unhelpful if a person has never actually expressed their wishes. So the new Act changes the guidance for medical treatment decision makers so that they will have to make a decision that they reasonably believe is the decision that the patient would have made for themselves. So how does a person make the decision they believe a patient would have made for themselves? The new legislation sets out the steps a medical treatment decision maker must take when making a decision for a person without capacity. And again, these are listed on the slide here. To be clear, these are the steps to be taken when there isn't an instructional directive, or if there is a directive but it isn't relevant to the decision at hand. So first, they must consider any values directive and then any other relevant preferences. If there is no directive or no preferences have been expressed, then the decision maker must consider a person's values and the effects of the treatment and alternatives to treatment, including refusing treatment, to decide which are more or less consistent with a person's preferences and values. A decision maker must act in good faith, which means that they have to act honestly and sincerely, and with due diligence, which in this context means being careful and taking steps to investigate and understand the benefits and risks of a decision. And they must consult with people that the patient would have wanted consulted. So what if it's not possible to find out and apply a person's preferences and values? In this case, the decision maker has to make a decision that, in the words of the new Act, promotes the person's personal and social well-being, having regard to the need to respect the person's individuality. According to the new Act, this means a decision maker must consider the effects and consequences of a treatment and alternatives to treatment, including refusing treatment, to determine whether these promote the person's personal and social well-being, And again, they have to act in good faith with due diligence and consult. So what happens if there's no decision maker? If there's no advanced care directive and no medical treatment decision maker, and a health practitioner has made an effort to find both, then there are two options. The new Act draws a distinction between significant and routine treatments. Significant treatments are defined in the new Act as anything that involves a significant degree of bodily intrusion, a significant risk to the person, significant side effects, or significant distress to the person. Routine treatments are treatments that would not be considered significant according to the definition, and guidelines are being developed about what significant and routine treatments are. Under the new Act, if the treatment is routine, then it can go ahead without the consent of the medical treatment decision maker. If the treatment is significant, then the public advocate can be the decision maker. And under the new Act, the public advocate will have to make a decision that takes into account a person's preferences and values or personal and social well-being, as outlined earlier. So what happens if your decision maker disagrees with your health practitioner? If a decision maker is refusing significant treatment and the health practitioner doesn't believe the decision maker knows the person's preferences or values, then the health practitioner must notify the public advocate. The public advocate decides whether the decision to refuse treatment is reasonable or not, and if not, they can ask VCAT to review the decision. So a couple of technical points to wrap up this section on substitute decision making. Firstly, if you've already appointed a guardian or a power of attorney, or if you appoint someone before the new Act commences next year, then these appointments are carried over. If you've made an appointment in another Australian state or territory, it is valid in Victoria if it complied with the law of that state or territory in which it was made, and to the extent that the appointment could be made under Victorian law. If you've appointed a decision maker in Victoria and then you move interstate, then your appointment should be recognised in the state and territory you're living in. But you should always check the laws of the state or territory where you are, because they do differ and they can change. And it's now my pleasure to introduce Claire McNamara, Legal Officer from the Office of the Public Advocate, to offer their perspective on how the new law supports people to plan for their futures.
Thank you, Sandra. The Office of the Public Advocate has long been involved with advising people about enduring powers of attorney, and you might have seen our publication called Take Control. It's been in publication since 1993, and we're up to our 12th edition. In more recent times, as there's been a lot of interest in advanced care planning, we have changed our way of describing things to talk about future planning. So our emphasis has moved from recommending that people think about appointing someone to be their medical agent to encouraging people to think about future planning, discussing matters with their agent, documenting them, reflecting and reviewing. And the new legislation provides an excellent platform to continue with this approach, which we believe will be much more accessible to most people. The main point about future planning is it's a process. You don't put it on your to-do list and tick it off one day and think, good, I've done that. You might do that with something like a will and only need to review it at some sort of regular interval of 10 years or when some significant change happens. But with healthcare, it's such a dynamic thing. It's a matter that requires constant contemplation, documentation, communication and review. It's possible that over time people have appointed someone to be their medical agent, filled out the form, perhaps handed a copy of the form to their medical agent and yet not had any sort of conversation with that person about their values and preferences. Perhaps because they haven't reflected upon it in the first place and therefore scarcely in a position to start communicating it to someone else. But the appointment of the medical treatment decision maker alone isn't going to equip that person to make the best decisions that perhaps they could if you invested some time in communicating your thoughts with them. So here we are in February 2017, and this piece of legislation doesn't commence until the 12th of March 2018. So you might wonder, what is it that I can do right now? Well, people have been doing advanced care planning for some time, and we can continue to do that. So I'll step you through the things that you can do at the moment that will be valid at the moment and will continue beyond that date of the 12th of March. If you haven't already done so, you could consider appointing someone to be your medical agent. That's an appointment under the Medical Treatment Act, and on the 12th of March that appointment would remain valid, but that person will become known as your medical treatment decision maker. Not everyone is going to want to do an instructional directive or even a values directive. But if you are a person for whom this is very important and you're quite impatient for the 12th of March 2018 to come around so that you can formalise that, my recommendation would be that you document your wishes as clearly as you can, because that document will still be extremely valuable to the person who is your medical treatment decision maker right now. And furthermore, as was mentioned earlier, the status of common law advanced care directives in Victoria is somewhat unsettled, and so it might nonetheless have that status. One of the reasons for the change in law is to introduce some clarity around that point. If you currently have some sort of condition, then you could complete a refusal of treatment certificate. And that refusal of treatment certificate will remain valid after the commencement of this new piece of legislation. But the most important thing to do is to work out what matters to you and what you want and what you don't want. And this is no easy task, and it's not something to think about on one occasion. Your ideas are most likely to be fleshed out by some personal introspection and then some communication with people, including your potential medical treatment decision maker, but perhaps not only that person. Casual conversations with friends, with colleagues, perhaps with other patients who are sitting in waiting clinics or chemotherapy wards with you. These are all good opportunities to try to work out what's important to you. Sometimes you work out what's important to you by hearing what other people say is important to them. We expect a lot of the people who might make decisions for us in the future if we haven't equipped them by doing some of this homework ourselves. One of the terrific things about this new legislation is that even though we've kept using this expression medical treatment tonight and haven't particularly defined it, the legislation in fact has a very broad definition of medical treatment. So it's not just what doctors might be doing, it's nurses, chiropractors, alternative medical practitioners, dentists. So all of these are matters that you might wish to think about that have particular significance to you, the sort of treatment that you would want, the sort of health care that you would be able to tolerate and what you would not be able to tolerate. The legislation introduces the idea of being able to appoint a support person, and this runs in parallel with the idea of a supportive attorney appointment, which is provided for in the Powers of Attorney Act, which commenced in 2015. The idea here is that the person doesn't make decisions for you. They're not a substitute decision maker. As the title suggests, they're there to support you. When people are going through difficult health experiences, it's often invaluable to have a trusted friend or family member sitting alongside you when you receive information from the health practitioners. If you were to appoint a support person, then that person would be in a position to be requesting information for you, perhaps at times that you don't feel that you're well enough to do that. So you can appoint a support person, but that role only functions for the period of time that you have decision-making capacity yourself. Similarly, you might want in your advanced care directive to think about medical research. You could indicate that you do or you don't want to participate in medical research. Again, this will provide some clear direction to your medical treatment decision maker. And just a little bit about the current resources the Office of the Public Advocate has. We have an interactive activity on our website called You Decide, Who Decides. When we developed this, we deliberately did not want it tied too closely to legislation. The idea is it's a bit of a values-based exercise, and if you go through it, it helps you try to work out what trust might mean to you, the sort of qualities that seem important to you to be in the person that you appoint to make decisions for you. So I highly recommend that as a starting point. That is a good activity to do alone maybe, or even to sit down with your planned medical treatment decision maker. You'll learn something about your own thoughts as you do that. We have the publication called Take Control, which explains about powers of attorney and has the forms in them. We have various fact sheets available on our website, and we have an advice service that runs ordinary office hours, 9 to 5, Monday to Friday, very busy, taking calls from a range of health professionals and from consumers. So please feel free to call us if you're wanting to explore any of these ideas. We're busy right at the moment trying to prepare for March 2018, which feels like it's coming upon us all too soon. We've got many resources to develop, resources for consumers, resources for health professionals. The Take Control will be updated. There'll be a variety of publications available on our website. They'll be available, I'm not sure what date, but certainly by the 12th of March and perhaps shortly before that. So in the interim period, as we lead into that new legislation, our advice staff will become familiarised with the current law and the law to where we're moving, because for some people, you might prefer to wait till the 12th of March to appoint someone. For other people, you might wish to do it right now. It's a very individual decision how you want to do things. The important thing, as has already been said, is to make an informed decision. So get some advice. Don't be frightened to call us more than once. You're welcome to call us as often as you need to get to the point where you feel like you've worked things out to your satisfaction. Thank you.
Thank you very much, Claire, and thanks, Sondra and Deborah as well, for those very clear presentations. We're going to move into the panel discussion in a moment, and I'll just reiterate some of the main points that the presenters made. So advanced care planning, remember, it's an ongoing process as your medical condition and or your values and wishes change. It's not something that you do once and then have finished with. You can participate as little or as much as you like. It's entirely up to you. And remember that appointments that you make and directives that you write can be updated. Just make sure that you let people know when you do that. So as we move to the panel session, it's my pleasure to introduce Sam Breen from Eastern Health. Sam is a dedicated and highly experienced nurse who is committed to the delivery of support and information to families to assist them to advocate for what matters most. Sam is an accomplished presenter, communicator, negotiator and listener, skilled in building strong relationships with stakeholders across medical, nursing, research, education and public sectors. Sam will join the panel to discuss the impact of the key changes for people affected by cancer and those who care for them. So we're going to start the panel discussion. We've got a few questions for our panellists to discuss this evening, and then remember that you'll be able to ask your own questions of our panellists during the online Q&A session that starts at 8 o'clock and runs until 8:30. So I'm going to start with the first question, and that's by asking Sam to reflect on the most significant changes for people affected by cancer and those who care for them, introduced by the new legislation from her perspective as an advanced care planning program lead.
Thank you, Jonathan, and good evening, everybody. I'm very grateful to be invited tonight. I think, as you've heard from the presentations, there's a lot happening in this space, but I think what I wanted to bring and to talk to you about is actually just thinking about your future health, and it actually can be quite confronting and complex, particularly if you have recently had a new diagnosis of cancer or any other disease. But I think what the changes that are coming will actually help support you through that process. It will enable a way for more open discussions about preferences for treatments, you know, what your concerns are, what your worries are. So it can help the doctors to make the right recommendations about your care, and it will also help your family to think about really the key things that really are important for you and for your family and friends. And I think one of the things we've recognised in health is that we can do things better. We need to be a bit more inclusive and recognise that, you know, what we think might be the right recommendation actually may not be. And I think it's really important to know that you have a voice. And through the new legislation of really giving clear guidelines and accountability to anyone that you appoint, actually gives you a voice at a time when in the future you could be the most vulnerable, you know. And I think that's one of the things we just really want to make sure that we are promoting the full picture of best interests and speaking to the people that know you best. So I actually think it's a very exciting change, but I also think it's also something to consider, to think about and reflect. And the more you do that, the better you can actually, I think, deal with the things that will come in the uncertainty in the future. Thank you.
Thanks, Sam. Does anyone else want to make any comments on that question, the most significant changes for people affected by cancer and those who care for them?
I think one of the things that's really helpful about this piece of legislation, it recognises the role of carers. There's also a piece of legislation in Victoria called the Carers Recognition Act, and a lot of the legislation in more recent times, including the Mental Health Act, has picked up on the importance of the carer's role. And so one of the principles in the legislation talks about a sort of shared decision-making. It involves the patient, the health professionals, and carers and other people who have an investment in the person's well-being.
Can I add as well? Sorry, I just also wanted to say one of the things that is really something that in health we could do is help support people when they have been given some information to tell their carers and to tell their family what's happening. And I think one of the benefits about documenting things is actually it strengthens any discussions, and it actually puts the person at the forefront of any decision. So people, your carers, your decision makers can make the right recommendations for you. And I think that's what we are really encouraging people to think about. But it is completely voluntary, which I think is again important to add.
Sorry, go ahead.
Yeah, I was going to say, I think one of the most significant changes, and it's one that Sandra spoke about a bit, is that move from a best interest test or criteria for decision making to the substituted judgment test, so that a person who's making decisions for you has to try to make the decision that you would have made for yourself, and that's a pretty big shift and a really important shift, and it's really important that you make sure that people know what you would want in that case. As Claire pointed out, it's very difficult for people to know what you value and what decision you would make if you haven't talked to people about it. So I think that shift in the test will really encourage people to talk to their decision makers about their values.
Yeah, and I think it emphasises the importance of appointing, if you do choose to appoint a medical treatment decision maker, that you appoint someone whom you trust, that you talk to them about your values and your wishes, you know, even talk to them about hypothetical scenarios and what you would want in a different situation, so that they are equipped to deal with decisions that might come to them that perhaps, you know, you don't contemplate at some stage, but it might come to you later on. So it's about not having one conversation, having more than one conversation, and I guess reiterating what things are important to you in different circumstances.
Thanks. And can I ask Sam again, can you talk a little bit about how you imagine that change playing out in the way that families have conversations, so how the change in the language might improve those sort of discussions?
Look, I think one of the hardest things is to, I heard someone say once that often opposites attract, and we can often have very different views on life with our partners, children, siblings. So one of the things I think where this is really good, because when you start to have a discussion about, and when we use the term values, what we're alluding to is talking about, it could be a spiritual, it could be religious, it could be to do with, pets. Pets are huge things in people's lives, and it's really about what is important. It's is it that I'm able to be social, or would I prefer to be, I like my space, I like to be quiet. And once you start talking about what's important for you, what it does do, it opens up that for other people to actually say to them. So you actually find that you're sharing information to each other that you hadn't potentially not known. So I think that helps inform everybody, because life is unpredictable, and I think as much as, if you're a person who has been given a diagnosis, it can be really confronting that suddenly everyone's expecting you to answer or think about all this stuff. So I think if we actually get everyone thinking about it, it actually makes it less pressure, because life is unpredictable. And I think, that any time is a good time to talk about this. Yeah.
And it sounds like those sorts of conversations are also going to have a really positive effect on the family left behind, where they end up as a result of being able to have conversations they may not have ever had.
Look, I think so. I have a background in organ and tissue donation, and one of the things that we always would hope for is that the family members would have a strong yes or a strong no based on what discussions they'd had. So they never walked away feeling, did we do the right thing or not? And I think it's the same in health in general. We want people to feel confident that they made the right recommendation and with the best of intentions.
Okay, thanks. Let's move on to the next question. So we've spoken a bit about what some of the main changes are. Where did this legislation come from? What have been the key drivers for these changes? Why has the law been changed? Why has it been changed now? Claire? And
yes, well, there have been some different government inquiries and a lot of consideration about these issues, so that in part is what's informed this particular piece of legislation. But essentially, I guess there was a need for some generational change in relation to the legislation. The Medical Treatment Act was made in 1988. I think Victoria might have been at the lead at the time of introducing such legislation, but things have moved on in all sorts of ways since then. And so partly what this new legislation does is take away some of the needless technical complexity that arises from the current legislation. There are different definitions, for instance, of medical treatment in the different legislation. There's also the confusion about the different powers a medical agent can have to refuse treatment compared to a person responsible being able to consent or withhold consent. It's a sort of technicality that most people can't understand, and so much better to have a law that is that makes sense to people and therefore can be applied consistently. There's also the lack of clarity around the status of common law advanced care directives, and the desire that many people have expressed over time that they would like to do an advanced care directive that relates to possible treatment that they might require in the future for a condition they don't currently have, because the law at the moment only allows you to do a refusal of treatment certificate for a current condition. So that's, and also I think a shift, as Deborah's mentioned, from the idea of best interests to values and preferences. Australia has been a signatory to various UN conventions since the time we enacted this Medical Treatment Act in Victoria, and so the whole idea of rights and preferences really comes from a international human rights framework. And so I think at a legislative level, as is often the case, the legislation is catching up with the other discourse that perhaps has happened on the ground and in academic circles.
Can I ask you to say a little bit more about that? So the previous legislation was 1988, or 98, was it?
Yes, the Medical Treatment Act is 1988.
So it's a long time. And so you started to talk about some of the human rights discourse, but can you offer any more reflections on what's changed over that period in terms of how we think about medical treatment and the relationship between the patient and clinicians and the role of the family?
Well, there probably has been over time a significant shift from a paternalistic model in medical decision making. Not that I'm suggesting that was necessarily the case in the 1980s, but going historically back a bit further, the idea of a doctor knows best and maybe decisions made without even proper communication to a person about what disease they had or what treatment they might need. You can read Victorian novels and see those examples, and it's not increasingly what has been expected. So in one way there's been a shift from a paternalistic model within the medical, hopefully there has been, and other professions. And similarly, the expression best interests is one now that probably people regard as a very paternalistic expression. And in our office, because it's an expression we need to use because that's a legislative definition, it's also the expression other people use. And so when people perhaps hold quite opposing perspectives, they'll all be claiming that it's in somebody's best interests. And it's not to suggest that the individuals who hold their views don't sincerely hold those views. But the problem with the best interests model is that it seems that people draw on a projection. It would be in your best interests to have dialysis because if I was in your situation, I would have dialysis. And so this shift in the language really is about being very clear, and it's why you need to be very thoughtful when you choose a medical treatment decision maker, that you choose someone who is able to do what is consistent with your values, which might not be your own values. And it's not to say that's not possible. I might want treatment that my mother doesn't want, but I'm prepared to make the decision for her so long as she's been clear with me about that. So I think maybe we see it all as a lot more of a collaboration and less of a mystery.
I think in some ways I still think there's a place for paternalism in-house because I think it's very difficult for people to make decisions about treatment unless they're given full open disclosure about what it might mean to withhold, continue, or when to stop, potentially. So I do think there is still a place for that in-house. I think one of the reasons, and Claire, I totally agree with the inquiries and legislative, but one of the things in-house is that we can actually, health is becoming more complex. We're getting better at what we do. People are living with illnesses and living longer. But we also have a dilemma sometimes, and all these complexities of what we can do is that sometimes potentially we could prolong a person's death. And I think that's one of the things that's been a professional dilemma for, are we doing things because we can, and is that necessarily what the person would want? So I think there's been a society movement into looking at how better ways we can communicate and open this discussion, because I think, I'm English, but but don't hold that against me, but but I do think that people don't like talking about death. They don't like saying, they don't like thinking about it, and I think this is one way to open up that discussion more openly. Yeah.
Okay, we'll move on to the next question, which I'll pose to Deborah. So can you talk about whether advanced care directives are portable between different states and territories across Australia?
Sure. So the new legislation for Victoria makes it very clear that advanced care directives made in other states and territories will be recognised in Victoria, although they'll only have the status of a values directive and not an instructional directive, but that will still provide really strong evidence of your preferences and values. If you're travelling to another state or territory with an advanced care directive you've made in Victoria, then generally that would apply in other states and territories. Most have legislation that recognises advanced care directives made in other states. There are a couple of states that don't have legislation for advanced care directives and rely on common law recognition of advanced care directives. So they won't have legislation that will recognise a Victorian advanced care directive, but the common law applies across Australia generally, so a directive made in Victoria would probably be recognised under the common law in those states. But I think the most important thing is still talking to people about your decisions, preferences and values, and making sure you're having the conversations and using your directive as a communication tool if you're travelling to other states as well. Make sure you take it with you, and then if you end up in hospital or at a health service in another state or territory, you'll have that to refer to, or your medical treatment decision maker or whoever you're travelling with will be able to provide that to clinicians who will refer to that when offering treatment for you.
So we're fast running out of time, but I'm going to ask one more question and take the person who can answer it most quickly. So given people attend a range of health services these days, public, private, inpatient, outpatient, local health service, allied health, so on, how can people best ensure that everyone knows about their wishes? Quickest answer we can.
Well, I think firstly the responsibility really lies with the person themselves. So they need to think about their own networks, who has an investment in their wellbeing, who they need to communicate with. If you put it into a filing cabinet and you don't tell anyone it's there, it may as well not exist. So whether it's your doctor or your other health professionals or the hospital that you think you're most likely to be taken to in an emergency, you need to think through who needs to see that documentation and make sure it's made available.
Yeah, and My Health Record is also an option that you can now upload your documents, so you can register through Medicare, but still, most importantly, make sure the people that can advocate you know that you have it.
Okay. So we're moving towards 8 o'clock when we transition into the online Q&A session. I want to, I'll make some very brief concluding remarks just to again thank all of our presenters and panellists for the excellent presentations and a really stimulating discussion. And we could have continued it for a long time, and we will continue it in the online Q&A. Can I invite the participants to make very brief final remarks, if they'd like to? Anything you want to emphasise?
I would like to emphasise that this is really a wonderful opportunity to start thinking about all of us to start thinking about our future, what matters most, and to have a situation in Victoria where the law will support us, and I think that's really good.
I think be curious. If you're a person who's thinking about doing this for yourself, be curious about trying to understand yourself, trying to understand other people. If you've been asked to be a medical treatment decision maker for another person, don't just accept it as some sort of honorary degree. It's not. It's a responsibility that's been cast upon you, and you need to be curious. Why have you chosen me? What sort of decisions do you think I might make? Who would you want me to consult with? What do I need to know? How often should I check in with you? Be curious.
I guess my reflections would be follow the law and follow what the legislation says, but don't be too hung up on the technicalities. It's really about appointing the person whom you trust to advocate for you, to communicate your values and preferences, and to continue having that conversation outside of what the legislation says you must and have to do.
And I would like to take the opportunity to put in a plug for the Office of Public Advocate resources. So I think if you want any more information following this webinar, or you want to look at some resources that will help you to do advanced care planning, then they have amazing resources on their website. And the interactive game that you mentioned, Claire, what was that?
Yeah, it's you decide who decides.
Yeah.
So, yeah, it's a good bit of fun.
Yeah.
And good to do with someone.
Yeah, I've had a look at that before, and it was really fun, and it's a really good way of examining your values.
Okay, so we'll bring this part to a close. Thank you very much to Deborah, Sondra, Claire and Sam, and also to Wendy and Sally Ann, who are here in the room with us.